All right, this is Attorney Reyes from RES Law, and I'm here to tell you the 4 top things you do not want in your will. The first thing you do not want in your will are specifically assets related to life insurance policies, annuities, IRAs, or bank accounts. All right, why is it that that is a bad idea? The reason it's a bad idea is because, generally speaking, each of those assets are able to be designated for beneficiaries. That means that when you open up that life insurance policy, they're going to ask you, who do you want to inherit all this property? If you go and say John Doe, your son John Doe, or your brother John Doe, but then years later you create a will, and in your will you say, I want the life insurance policy to go to my niece Mary, what happens? There's a direct conflict between your beneficiary designation and your will provision. If that happens, Mary is not going to be too happy with you, because John Doe will inherit those assets because the life insurance policy will designate to John Doe, and that asset will go flow straight into John Doe, not Mary. But why? Why does that happen? Remember, if you have a beneficiary designation, the asset will not go through your will. That means if you have an annuity, an IRA, or a bank account, and that has a designation into that account as a specific person, that specific person will inherit that asset. So you don't want your will to have a contradiction, because that just creates conflict. Simply put, there is an exception specifically related to the IRAs, because if you name your estate as the beneficiary to your IRA, and then you go and say in your will that you want that to go to Mary, niece Mary will inherit that IRA. That's an exception. Generally speaking, a designation to a beneficiary will trump whatever you put in your will. How does that make any sense? Why? Your IRA, your life insurance, your annuity, your bank account, if it has someone else listed on there, as soon as you pass away, by operational law, it goes automatically to them. It doesn't wait for the will to be probated. Remember, once there's a will, it has to be taken to the court for the court to administer that will, to probate that will. That takes some time. This transaction, if it's a beneficiary designation, happens instantly. So you want to make sure you take that into consideration. Where are your assets designated? Who are your beneficiary designations? That is going to dictate who gets that money, who gets those assets. You don't want your beneficiary designations to contradict with your provisions on the will. That creates conflict, it creates issues, and it makes you, the creator of that will, look pretty dumb. You don't want to look dumb. You don't want your legacy to look dumb. You don't want to create conflict in your legacy. Therefore, make sure that those beneficiary designations are consistent with the terms of your will. Next, there are some assets that do not go to your estate, specifically assets that are already in a trust or assets that are in an LLC. Remember, assets that are held in each of these entities are separate entities. If they're separate entities, they pass through by operational law as well. They do not go to the estate. The trust, for instance, if you have a trust and then you have a will and the trust has the home inside it, now that trust indicates that the property will go to this person, to whoever it is. If that provision in that trust says that it's going to go to John Doe, that trust will dictate and will trump that will. If that will said that same home is to go to the niece Mary is not going to be happy. She's going to end up thinking she inherited a house, and now that will says give the property to this niece, and now the trust already designated that beneficiary to be John Doe. John Doe will grab that house by operational law and immediately inherit that house. Niece Mary will not get the house. That's a no-go. That's a conflict. That's a problem. You look dumb. That's not bueno. No bueno. So you want to make sure that your trust and your will are consistent. The beneficiary designated in that trust actually coincides with whoever you're trying to leave other property, and the properties don't conflict. So the same thing happens with an LLC. Kind of different though. An LLC usually is some kind of business entity, some kind of entity that has an operating agreement, bylaws. Those provisions will dictate what happens to that property. You don't want your will to say that a building or a business goes to, sorry to say it, niece Mary again. Your will says niece Mary is going to get this business. Let's say it is a real estate business. Let's say it has certain investment properties in that LLC. But then the will says it goes to Mary but the LLC agreement says is to be distributed among the owners, let's say. That is a contradiction. That creates an issue. You don't want contradictions between the LLC and the will, because then that's not good for the beneficiary of the will. Number 3, there are certain provisions you do not want to put into your will because it is too late by the time that the will is probated. Which ones are those? Funeral arrangements, organ donations, life support decisions, and guardianship nominations. Remember, when a person passes away, a decedent passes away, certain things need to get done, such as a funeral, such as arrangements for their bodies to be moved from one location to the other. They need to make sure while they're alive, decisions related to their life support, nutrition, types of medicine that they're going to be taking. Those decisions should not be put into the will because the will talks about the estate administrations of the assets, not what's happening to that person's body. Therefore, you don't want to conflict the terms, and you want to make sure that the provisions and the proper requirements on a will, it don't conflict with what needs to be done actually in a New York living will or a healthcare proxy and those kinds of medical documents that require their own types of procedures to make sure that they're properly executed. If you have that information in a will and it's not proper, such as it doesn't have the number of witnesses required, it doesn't have the notarizations if it's required, whatever is required in the state at the time that you're viewing this video, now you have an invalid designation or you have an invalid document that doesn't confer the power to that person. So you want to keep them separate. Keep the decisions for medical decisions, body arrangements, organ donations, life support, and New York living will provisions separate from the will. Now, if you have a minor child, you have a particular interest to what I'm going to say next. Specifically, you don't want your will to say who is going to be nominated as a guardian. Who do you want to get your children upon your passing? Because remember, when you pass away, the thing that's going to happen is someone needs to go to the court and take that will to be probated. You don't want the decision as to whether the will is valid, the probate, to determine whether that person will be designated as a guardian or not. There are other ways to do it, which will require you to actually execute a guardianship nomination for temporary guardians, permanent guardians at the specific stage right after your passing. You don't want it to be tied to a probate of a will. Remember, there's only one will that's executed. Once it's executed, that one will, the original will, gets taken to the courts. If you don't have that will anymore, how do you have anything to stand in the way to make sure you can do the guardianship nomination? That's why you want to keep those two separate. You don't want the designations to be put in a way that conflicts, and that then you have to wait for the judge to stamp while your kids are in the foster system with a stranger or with no guidance whatsoever as to who is going to be taking care of them. The fourth thing you do not want to put in your will is illegal gifts. You know, these kinds of things are common sense, but you see them. People do them. People make a choice, right? They'll write a will out. They basically say, hey, I want to give this thing. I want to use this money for an illegal purpose. And look, sometimes, especially with the changing nature of the laws, you may think for a second, hey, somebody's not going to do that for a reason. But remember, under federal law, on the date of this video, specifically July 2021, it is still illegal for marijuana in the federal level. If marijuana is illegal in the federal level, a decedent can't go and say, hey, I want this property to be used for a dispensary of marijuana. It may be, it's an interesting question of federalism, whether it can be done in the state in which it's legal and recreational and medically possible. But if it's not legal in that state, but you don't want to make a bequest that empowers someone else to then create an illegal industry. There, we have given you the 4 tips, 4 things you do not want in your will. If you have any of those things in your will, give us a call, set an appointment. We'll help you create a codicil. We'll fix the will that you have to make sure that it conforms to the actual plan that you really want. We want to understand, where are the assets that you want to go at the end result? What is the conclusion that you want? And then we can move the assets however you want. So make sure that first, the beneficiary designations are all checked. That falls into the first top thing you don't want in your will. Then you want to make sure that the assets that you actually put into the will are actually not encumbered by some other asset, such as a trust or an LLC. You want to make sure that these assets actually consistent to one another, meaning the LLC and the trust are consistent with the distributions that you're making in your will. You don't want inconsistent distributions. That creates problems. And it also makes you look like a dum-dum. So let's not do that. Let's make sure your legacy actually communicates the last dying wish to your family, which is a love letter that joins your family together instead of separating them. The third thing you don't want is for decisions that need to be made immediately to be encompassed inside your will. There are specific documents like healthcare proxies, funeral arrangements, and the living will that get done through those documents, not through the will. And guardianship nominations for people who have minor children, you definitely don't want to put that in your will because the will needs to get probated, and that takes time. So you don't want your probate to hold up what's happening in the guardianship. Then the last thing is illegal gifts. There's a lot of different ways that people get creative. You just want to make specific gifts, such as specific amounts of money or specific property given to an individual. Don't want to leave property behind to someone else and giving them to do an illegal industry or something like that. So there you have it. You got 4 things that help you make sure your will is good. And we welcome you to make a consultation with us. We'll help you out. Take care.